welcome to our webinar where we will be discussing what your options are of having your significant other or family members come to the United States. So in a relationship with a foreign national, what do you do now? All right, Alcorn's story. What do? We are a group of passionate individuals who do our best to influence positive change in people's lives. As our motto really is here, we overcome borders, expand opportunity, connect the world by practicing compassionate, cutting edge, rigorous immigration law in service in the betterment of humanity. Our goal is to help everybody who wants to realize their American dreams one way or another. Here's my mouse. Our team, we are a devoted team of individuals. This is myself. I'm a partner here at Alcorn Immigration. I studied at Santa Clara Law School, and I'm a proud UCLA alum. My expertise and passion is in family-based immigration. I have experience practicing family law as well, helping people with custody issues, divorce, and all of those. But I have a passion for family-based immigration. I'm an immigrant myself. I immigrated to this country when I was 4 years old with my parents and my two older siblings. I am Armenian, so I was raised in a very strong Armenian community, but I was born in Iraq. So a little mix of everything, like the melting pot that is America. This is Sophie, our fearless leader. She is the founder of our practice. She is certified as an immigration law specialist, and she's absolutely fantastic to work with. She has assisted thousands of startups and individuals with U.S. immigration. She is an author at TechCrunch, and you can see her on the stage of various TechCrunch conferences as well. And she is fantastic. This is our team. We could not be where we are or who we are without the incredible people that we work together with. Currently we are a firm of 5 attorneys and all of our supporting staff. We are continuing to grow, and so looking forward to this new year. Even though we're about a fourth of the way done. I went to law school to not do math, so sorry if I was wrong. But we work together to help everybody realize their American dreams. This is me over here. This is my green card when I first moved to the United States. That's my sister up top. As you can see, the green card is pink, and we are considered, I think we're aliens. We're resident aliens of the United States. Green cards have changed a bit, but that's a little old me. Our little clicker is not working. And this is my American dream. This is my family. My parents immigrated to the United States so that we do not have to live in a war-ridden country. Here we are in Iraq. I think my sister's face maybe cut off. But here we are, pictures of us in Iraq. My parents tried their best to shield us from danger and protect us as much as they can, but they realized that the only way they could really do that is if we moved to America and lived our dream. At the 20-year anniversary of my family moving to the United States, both my sister and I graduated from law school, and we could not be more thankful to our parents for bringing us here to this country so that we can now help change others' lives as well. This is my dog up here in the middle. He's our little superhero. He comes to the office with me sometimes. And this kind of gives you a little picture into all of the work that is involved in putting together immigration packets and applications. He is the emotional support that all of us really need here at our office. This is Sophie's grandfather's naturalization certificate. He immigrated to the United States from Germany, and it the naturalization certificates have changed a bit as well, where here it says he has a right arm that's bent and a broken thumb, to kind of categorize people, I suppose. I'm sorry, he wasn't from Germany, he's Italian. Maybe I need to speak with Sophie a little bit more about her background. Alcorn Immigration Laws Network, we have a strong network of people. So our network is our clients' network. So whoever it is that we are working with and we are representing, we like to connect with other people so that they can not only focus on bettering their immigration lives, or their immigration portion of their lives, but also if you need a financial advisor, if you need somebody to help you with a will or trust, if you want a prenup and you're thinking about it but you're not entirely sure, let us know and we'll connect you with people who can help you as well. We have the privilege of working with some brilliant clients that come from fantastic universities, and we, in addition to representing family-based clients, we also have a large portion of our practice that's for business immigration and employment-based immigration. These are some of the people that invest in our clients, and then we support employees from these companies as well: Facebook, Apple, Instagram, Google. We don't necessarily represent these clients, but we help individuals who work at these companies. We're mentioned and featured in several publications. Here's some of the awards that we won. This is our newest one, our women, we're certified women's business enterprise. We are women-owned, women-led, and some companies and some individuals are really enjoy that. All right, so introductions aside, what do you need to know about immigration law? Immigration law is complex. There's so many different moving parts at I feel like any given time. There's never a dull moment. That's my motto, I feel like, in life. And it's always changing, always evolving, and we're always on our toes. Always something new to learn with immigration law, which is fun. So it's complex. People can get visas, people can get green cards, people can become citizens. There's two really pathways for immigration. People usually think, oh, in order for you to first get a green card, you have to have a visa first. That's not necessarily the case. Sometimes people can enter the United States on a visa of some sort, whether it's an H-1B, a visitor's visa, any other kind of visa, and then they adjust their status to green card, and then eventually they qualify for citizenship as well. Also, you can enter the United States as a green card holder. It's technically called an immigrant visa that you're entering in on, but you can enter as a green card holder with the ability to work right away, with the ability to travel, and then eventually can qualify for citizenship as well. Understanding the options that you have. So there's, again, different categories of immigration. There's the diversity lottery, where some countries allow you to enter into a lottery where you can put your name in, put your family's information in, and if you're selected in the lottery, then you are chosen and you can obtain a green card. There's self-sponsorship, you can invest your money in the United States, and you can come to the United States that way. Employment-based immigration, if you have an employer who wants to sponsor you for some sort of visa, whether it's an H-1B visa, somebody with specialized skills, if maybe they want to transfer you from an entity that already exists abroad and then enter the United States to work at the affiliated United States company. And there's family-based immigration, which is the main topic of discussion today. So green cards through marriage. Actually, let me go back to this. I'm going the wrong way. There we go. Family-based immigration. So family-based immigration, there's different preferences. There's different categories that people can invite their family members over to the United States. United States citizens can bring over their parents, their siblings, their children. Those are the main categories. Some take longer than others. For example, the sibling category takes about anywhere between 13 to 20 years for somebody to come to the United States, whereas if you're a United States citizen marrying a non-immigrant, it takes closer to about 1.5 to 2 years to enter the United States. And there's just different ways people can qualify. A United States citizen can petition for their parents to come to the United States. So there's different family members that could qualify for green cards. A green card through marriage to a United States citizen. So this is the adjustment of status portion, the adjustment of status way to get a green card. So let's say somebody is in the United States already, maybe they have an H-1B visa, and they entered legally. They were inspected by Customs and Border Patrol at a port of entry, and they have status here for any given amount of time. And they're either married to a United States citizen already, or they get married to a United States citizen. That allows them to file what's called an adjustment of status with USCIS, United States Citizenship and Immigration Services, here in the US. So you file a large application that essentially says, hey, I have an H-1B visa, or I have status, I entered here legally at some point in time. Maybe you're an overstay, but you initially entered the United States legally. I'm now married to a United States citizen, and I want to get my green card based off of my relationship to this United States citizen. Meet with me, speak with me. I can kind of walk you down the journey and see whether or not you qualify. If you do, then we can start the journey. So you start working with us. We put together a package of information and documents to prove to United States, to USCIS that you qualify for a green card. There's 5 main forms that are involved in the application process. One of the forms are to prove that the United States citizen does have a relationship with the foreign nationals that they have married. And it requires evidence to support that. So you have to prove lease agreements if you guys lease a home together. Maybe you guys own a property together. Documents of that nature to anything that has both of your names on it together to prove to United States Citizenship and Immigration Services, USCIS, that you have a real relationship. It's bona fide, it's real. You love each other because you love each other. That's why you got married. You didn't just marry this person to get a green card. So you provide documents of that sort. Maybe you have children together already. Provide the birth certificate, bank records. USCIS loves to see that people have their finances commingled, essentially, where they have a shared bank account where all of their money comes in and then goes out from there. They love seeing that. They love people who they file their taxes jointly, have each other listed on 401ks, trusts, life insurance, anything that can have both of your names on it together. That is a huge plus because it boosts your application. So in addition to proving that you have a bona fide, a real good faith marriage, you also have to prove that the foreign national is eligible for a green card. And the way to prove that is by, of course, providing the documents, but we screen them as well to make sure they've never claimed United States, they've never claimed US citizenship when they're not really US citizens, that if they have crimes, that there's no disqualifying crimes, anything of that nature. So we put together a package. There's a 485, which is the main green card application, and a couple of other forms as well that we put together. And we mail it off to USCIS. Once the USCIS receives the package, then within about, I would say, like 3 to 4 weeks of receiving the package, we'll get receipt notices from USCIS saying, thank you, we've received your documents, and processing will continue. After that, the foreign national, so the immigrant spouse will be invited to the local USCIS office to have their fingerprints and photo taken. So that's when the background check really begins with USCIS. Then within 7 to 8 months of filing the green card application, initially the foreign national or immigrant spouse is given the authorization to work internationally as well as travel internationally, assuming the person is eligible to travel internationally during this period. The work permit is called an EAD, an employment authorization document. It allows the employee to work anywhere in the United States with no restrictions. If the person can travel, I usually like to talk with my clients about any travel plans that they have first before, and we go from there. But yeah, so they have the authorization to work with that, and it's essentially, it gives you freedom to work wherever you want. If you have an H-1B or any other underlying status, maybe another visa status, I always tell clients, try the best that you can to maintain your underlying visa status, because it's a security net. So keep your status if you have status, and on the side, if you want to start another little business on the side, go for it, because now your EAD allows you to do that. Once the application is filed, you and your spouse will receive an interview notice, and it's usually around 12 to 18 months, sometimes a little bit longer, depending on where you're living. You will be invited to the local USCIS office to be interviewed by a USCIS officer. Where at that point in time, they will ask you questions. They will go through the forms with you again. They will ask you questions about your relationship. They will ask you questions about any criminal history that you may have, or anything that could come up in the application process. The officer gets to ask you those questions. Before the actual interview, a service that we offer is we prepare our clients with a mock interview, a practice interview. So we'll have our clients come in, we'll prepare them for the interview, we'll give them tips and tricks of what to expect at the interview, what to say, what not to say. We'll put together their documents. We ask, bring your original documents with you, and let's organize them. We'll put them into little packages. We'll post-it note them. We'll put them in the order that we think that will be important to present to the officer. We'll tell you what exactly you should do. And in addition to that, we prepare a supplemental package to give to USCIS to continue and supplement and prove that the foreign national qualifies, and this relationship qualifies for the foreign national to get their green card. I see a couple of questions coming in already. I'm going to wait to answer the questions at the end. And I see your questions, and I will answer those at the end. And we'll go from there, if that's okay. And then so we prepare for the mock interview. Sorry, going back to the questions. If you guys have any questions, there is a Q&A that is open. Please ask your questions there. And if it's appropriate, I will answer them. If not, we can maybe set up a consultation, and we can discuss further. So we prepare for the mock interview, and then, assuming again, we are representing you, we attend the interviews with our clients. We do not like to send our clients alone to these interviews. I oftentimes do see people going to these interviews on their own, but it makes me hesitant to even think about sending my clients to these interviews alone, because you never know what will happen at these interviews. An officer may ask or say something that you're not entirely sure what to say or do. So again, having an attorney at your side at these interviews is critical, in my opinion. And then after the interview, assuming everything goes well at the interview, usually the clients can expect to receive their green card in the mail about, I would say, like a month or so after the interview. Officers do have 120 days after the interview to ask for additional documents, to make decisions. Typically, the clients that we work with, this doesn't happen. Sometimes cases take a little bit longer for an officer to adjudicate or make a decision on. So it really all just depends. But we're with our clients the entire way. With all of my cases, after an interview, I check on the case status of the cases that we work on a daily basis, because for me, it is exciting for me, as I'm sure it is for you. every single case is victorious for me, and all of our associates as well. So they're all really important to us. Green card through marriage, through the consular processing route. So this goes back to the immigrant visa, somebody entering the United States with a green card already. So let's say I'm married to somebody who lives abroad, and they don't have status here. They don't have a way to enter the United States, or they don't have status here already for us to get married and file an adjustment of status. You can still get your green card, but it's done at the consulate abroad instead of in the United States at a local USCIS officer. It's a 3-step process. The first step is you file with USCIS still. It's still that same initial petition that the United States citizen, or maybe you're a green card holder. Already, the individual is a green card holder. So if you're married to a United States citizen, or you're married to a lawful permanent resident, or somebody who has a green card, you file the it's called the I-130 petition for alien relative. You file that here with any proof of your good faith marriage. Again, that gets adjudicated by USCIS. Typically takes about 6 to 8 months. And then step 2 of the process is it gets forwarded to the National Visa Center. The National Visa Center is an entity in the United States, again, that does document collection for the consulate. In my opinion, the National Visa Center has a very difficult portal to work with. We will wrestle with that portal for you. You don't have to deal with it, but they're very, very specific with the quality, color, orientation of the documents that we have to provide to them. So we provide the National Visa Center with documents once the National Visa Center has initiated the case. Once they have everything that they need for the consulate, they will schedule the interview at the consulate, and will let us know, hey, your interview has been scheduled at the consulate. This is what you need, and this is what you should be doing. So we'll inform our clients, hey, your interview has been scheduled. These are the next steps. Again, we'll do a mock interview or practice interview with our clients. Clients attend the interview, assuming everything goes well at the consulate. They will put a stamp in the passport of the foreign national, with which the individual has 6 months to enter the United States as a green card holder. And they have, again, the ability to work right away. They're a green card holder, so they have those rights already. So that is the consular processing route. Again, if you're married to a citizen, or maybe somebody who's a green card holder. If you're married to somebody who's a green card holder, they are subject to the visa bulletin. They fall under the F2A category. And historically, there's usually been about a 2-year a backlog of 2 years where people who fall under the F2A category have to wait a bit longer for a visa to be available, or a green card to be available for these people, or for the individuals that fall under the F2A category. As of August of 2019, the F2A category was actually current, so that meant there was no line. That line is now building up again, so we, on a monthly basis, check the visa bulletin, which is what dictates the F2A category. We check it and we make sure what it's looking like now. Right now, it's in February, it's still current. In March, it is the backlog is growing a bit. A K-1 fiancé visa. So let's say I'm not married to a citizen yet, but we're engaged. It allows somebody to enter the United States on a single-use visa, and then once they enter the United States, they have to get married within 90 days and then file the green card application. It's not as simple or as funny as it seems. On 90 Day Fiancé, I don't know if anybody watches it on TLC. Funny show, but it's not as glitz and it's not even glitz and glamour there. But again, you have to be engaged to a United States citizen. You file a K-1 visa petition, which is similar to the I-130 petition that somebody who's married to a United States citizen would file, but it's a little bit different. It's a K-1 visa, so it's a different type of petition, different type of proof. You have to prove that you have met in person at least one time, preferably at least 2 times. And you have to prove that you have this ongoing relationship, and you also have to essentially declare that upon entry into the United States, you are free to marry and that you will be married within 90 days. So again, with this one, the applicant attends an interview at the consulate. They will be issued a visa with which they have to enter the United States within 4 months. And then you get married within the first 90 days, and then you file, going back to the adjustment of status, which was the first slide that I went over. And you go there with that. And that is there again. Moving forward, conditional green card. So some individuals, when they get their green cards, some individuals will get a 2-year green card that's a conditional green card, versus others will get a 10-year green card. Those who get a 2-year green card, or those who have not yet met their 2-year wedding anniversary when the green card was approved and issued. If you have not met, maybe you're only, you got married within a couple of, you filed the green card application immediately after you got married. You get a conditional green card because, again, you have not yet met, wow, that's difficult to say, not yet met the 2-year anniversary of your marriage. It's 2 years because USCIS wants proof that the marriage is real and that the marriage has continued. So it's providing additional good faith marriage documents to prove the existence of the marriage. And maybe within those 2 years of having your green card, maybe you had a baby. You provide proof of that, or maybe you're pregnant, providing proof of that, providing evidence of your good faith marriage to establish that you married for love, you didn't marry for a green card. Others who have already met the 2-year wedding anniversary when the green card was issued and approved get a 10-year green card. They don't have to worry about proving to the government that, that the marriage still exists. One more thing to consider, it may be on the next slide, but I'm not entirely sure. Nope, it's not. What happens if I got married, I have a conditional green card, I got married, it didn't work out. I hope none of you end up in that category, but if you do, there's still ways around it. You can still get your green card if your marriage didn't turn out. Still, you do have to prove that when you initially got married, you married for love, you didn't get married for a green card. So you still do have to provide as much good faith marriage documents as possible. Again, good faith marriage documents are those bank accounts, 401k sharing, credit cards, PG&E bills, phone bills, anything that you can show a real relationship existed, photographs of your relationship. I know some people don't like to take photos. Whenever I meet with clients for the first time, I always tell them, now is your time to love taking photos. Take photos of everything that you can. The more photos that you take of your relationship with family and friends, the better. The more selfies that you have, yes, we're in a time where everybody loves to take selfies. The more selfies don't necessarily prove a good faith relationship. Selfies show that you and your spouse have a relationship, but if I can show a picture with me and my spouse and our parents, or me and my spouse and our cousins, or our friends, and here we are at this event with all of these people, it shows that you're out there, you're proud of your relationship, and it's a real marriage. It's a real relationship. So those are little things that I like to have people keep in mind. VAWA, this is a self-petition. It stands for Violence Against Women's Act. You don't have to be a woman to qualify for VAWA, but if you're an individual who is the victim of violence by a United States citizen or green card holding spouse or parent, you could be eligible you could be eligible for a green card or status through VAWA. You have to have been physically present in the United States for 3 years. You have to be a person of good moral character. And you have to prove that if I were to go back to my home country, that I would suffer extreme hardship, or maybe my child that I have with this spouse will suffer extreme hardship. It's a long process. Again, it's a self-petition. You don't have to prove that you're still in a relationship with this person. You can still be married, you could be divorced, but if you're divorced, it has to be filed within a specific period of time to make sure that you're still eligible. So if you're in this category, I hope you're not, or if you know somebody who is, I would definitely speak to a legal professional about this one. Supporting law enforcement. So this is, again, one of those categories that I hope none of you or your loved ones fall under. This is a U visa. If somebody is the victim of a specific type of crime, can qualify for a U visa. They must have suffered substantial physical or mental abuse based off of the specific crimes. They have to possess information regarding criminal activity. So they must have information about whatever it is that they were the victim of, and they must have been helpful in the investigation or prosecution of this crime. With this, we have to work with local law enforcement to get that certification that this person, yes, was indeed helpful during investigation, and that they do, it is this specific crime that USCIS speaks of, that they were a victim of. There's a couple of crimes that jump back and forth of whether or not it's a qualifying crime or not. Again, this is one of those that I would highly recommend working with a professional towards. It's not an easy one, and it takes a really, really long time to get a green card in this visa category. Citizenship. So this is kind of interesting. So typically people hear, yes, you have to have been a green card holder for 5 years in order to qualify for citizenship. But if you're married to a United States citizen and you have been married and have been living with this United States citizen for 3 years, you actually qualify for citizenship sooner. So again, with this one, if you're not entirely sure, 5, maybe 3 years, you can qualify for citizenship. You have to have physical presence here in the United States for 50% of the time of the eligibility period. So it's either 50% of 3 years or 50% of 5 years. You have to have spent that time here in the United States. And the way that is proved is you have to write down, this is the day that I left the United States. This is the day that I entered. My trip was not longer than 6 months. If you have any trips longer than 6 months, it may restart that, either that 3 or 5 year clock. So again, talk with a professional about that if you have that, if you fall under that category. So you have to prove your trips in and out of the US. You have to be a person of good moral character. So people who are on probation, we tell people hold off until probation is over, and then that's when your 3 year window will start. So let's say I ended my probation on January the 1st of 2020. I would wait to file for citizenship, and maybe I fall under the 3 year category. I would not qualify for citizenship until January the 1st, 2023. So that it restarts that 3 year period of eligibility. And unlike a green card, to qualify for citizenship, in addition to going to an interview at USCIS, you also have to take a test. They test you on your English proficiency. So they'll test your English reading, they'll test your English writing, and then they'll give you a civics test. They will give you 100 questions for you to study from. Of those 100 questions, they will ask you up to 10 of them. As soon as you get the first 6 correct, then you have passed the exam, and you can then continue with the rest of the eligibility requirements of citizenship. If you fail that exam, whether it's for the English reading and writing, or because you didn't study those 100 questions, you do have the ability to take the test one more time. If you fail that second time, then the citizenship is denied. What happens if my citizenship is denied? Do I lose my green card? Not necessarily. It really all depends why citizenship is denied. So that question really depends. If citizenship is denied because you failed the tests, not a problem. You can just reapply for citizenship and this time study those 100 questions. So similar to the green card process, again, it's preparing an application, filing that application, having your fingerprints taken, preparing for the interview, attending the interview, assuming everything goes well at the interview, then you're scheduled for an oath ceremony, and it's at that oath ceremony that you will become a citizen. You don't become a citizen after your interview. You become a citizen after you have given the oath of allegiance and are sworn in as a United States citizen. Once you're a citizen, again, your ability to sponsor your family members increases. Citizens can sponsor their spouses, their parents, and even their siblings for green cards. Undocumented individuals, we do have some clients who are undocumented, and we work with them. Let's say we have somebody who crossed the border, who entered the United States without permission to be here when they were younger, and they have now since married a United States citizen. They could qualify for it's called a provisional waiver. It's a pardon essentially for entering the United States illegally, staying in the United States over that period of time, and it's a pardon, it's forgiveness. But in order to have that forgiveness given to you, you need to prove that I have a qualifying relative here in the United States that would suffer extreme hardship if I had to go back to my home country, because I'm barred from the United States for either 3 years, 10 years, or maybe permanently. If it's permanent, it's a different question or issue that we would have to address. But we would prove that this person would suffer extreme hardship if I were either my qualifying relative would have to move with me to my home country, or my qualifying relative and I would be separated for the period of time that I am barred from the United States. The individual enters the is in the United States the entire time during this process. However, the final interview is done overseas at the consulate of their home country. Once they go to that interview abroad, they are permitted to re-enter the United States, this time as green card holders. So it's a little combination of being in the United States plus that consular processing route. So when I speak with clients for the very first time, or potential clients for their very first time, I ask them a lot of questions. There's a lot of questions that I need to understand to make sure that individuals qualify. I ask, what country were they born in? What country are you a citizen of? Sometimes it's multiple, or it varies. When did you come to the United States? How did you come to the United States? What are your goals? That's my very first question. I ask, what are your goals? First, what are your goals of this conversation that you hope to get out of this conversation? And then what are your goals of living and working in the United States? How quickly do you want your spouse or your fiance to come into the United States? What's your current status? What have you done for your immigration status so far? Are you married? That's an important question. Do you have any children? Were you previously married? Have you ever been arrested or convicted of any crimes? Have you ever had any immigration issues? Have you had a visa denial, refusal? Maybe you were refused at the port of entry. And questions that I need to understand, or any immigration attorney or even officer will need to understand to confirm eligibility. Changes to immigration law. So like I said a bit earlier, there is never a dull moment in immigration. There's always changes. There's always something going on. This is the most recent change. The public charge updates. This became effective as of Monday, February the 24th. There's new public charge rules that require individuals to prove a lot more information when they're applying for green cards, and sometimes other types of non-immigrant status here in the United States, to prove that when they enter the United States, they will be self-sufficient. They're not going to be a public charge. What does a public charge even mean? It means when you come into the United States, the government doesn't have to give you any money. So previously, the old rule really was rarely applied. It was pretty vague. The main consideration was the I-864 sponsor. What is an I-864? It's an affidavit of support. Typically, it's the petitioning individual, so the United States citizen spouse, essentially has to prove that they make enough money that they can financially support the individual that they're inviting to the United States. And at that point in time, if the person does get welfare, any sort of public benefit that does indebt the government, the sponsor was responsible to pay back the government for whatever it is that the foreign national spouse, the immigrant spouse, took from the government. Again, before, it was rarely applied. It was pretty vague. The questions on the application previously were just, Have you ever received public assistance? Yes or no. Are you likely to receive public assistance? Yes or no. So it's now with that, are you likely to receive public assistance, that there's this new public charge rule. They look at a couple of different elements in a totality of circumstances to see who could or could not possibly be a public charge. And it all comes really together with the entire application. And with public benefits, they are actually looking into public benefits that people are getting. If an individual has received 12 or more months of public benefits in a 36-month period, they are inadmissible for green card purposes. And again, a lot of information, there's a new form, it's the I-944, a lot of information that is requested on this new form. Not many people know much about the I-944 right now, unfortunately, just because there's a lot of resources out there, but not many people, nobody will know really what to expect or what to do until we're actually faced with the form at an interview in front of an officer. The officers don't have these forms yet because it is a new requirement. So knowing exactly how this will play out is still to be determined, but we are doing our best to educate ourselves and work with our clients to put a strong case forward for them. So what are the totality of circumstances that they're looking at? They're looking at age, they're looking at health, they're looking at the family status, they're looking at assets, resources, financial status, education, skills, what the individual's immigration status was, and what the period of admission is, and again, the I-864 affidavit of support. So with these, going back from the top, the resources that are available to us so far, the guess or assumption so far is that it's from order of importance. So they want to see, how old is this person who wants to enter the United States and get their green card? Are they going to be able to financially support themselves? Are they going to request any sort of benefits? What is the health of this individual that's entering the United States? Are they going to require health care? Are they going to pay for their own health care? What is it that the government is going to have to give to this individual? Family status, they're going to look at what the status of the family is, the financial status of the family is. And again, they'll look at the assets, resources, and financial status of everybody in the household, in the petitioner, the applicant, him or herself. With this one, I have the hardest time wrapping my head around this. USCIS is going to start requiring people to provide their credit scores, which I think is very interesting. We have to provide the credit scores. What is a good credit score for USCIS or for immigration purposes? We're not entirely sure of just yet because it could vary. So again, we're working, educating ourselves and learning as we go with this one. Education and skills, they want to see, are you entering the United States? If you're 25 years old, do you have a bachelor's degree? With that bachelor's degree, are you going to be able to find a job if we give you a green card and get and be able to be self-sufficient? That's what they're looking at. Immigration status, they want to see how long what is the status that you're entering in on? How long are you going to be here for? Oh, I see you want to come here as a green card holder and you plan on living here indefinitely. I hope you're young, I hope you're healthy, I hope you have a good degree, because we don't want to support you. That's how the government is thinking when it comes to these public charge considerations now. So we are here to support you. We will do whatever we can in our power to put a strong case together for you if we work together. I now am, if anybody does have any questions, please add it to the Q&A chat box. I'm going to go through the questions and I will read through them and answer whichever questions that I can answer together, and we'll go from there. Would this be, okay, so we have a question here. Would this be the same route for my fiance who is DACA? So that question all really depends. with this question, we have to see, did the fiance enter the United States legally, or did they not? If they entered the United States legally, then there is a potential pathway for a green card. So maybe yes, but if your fiance did not enter the United States initially legally, then we would have to look into potentially the I-601A provisional waiver to get forgiveness for that initial unlawful entry. All right, next question. I'm a European and I'm engaged to an American. I live and I work in the US. I have a driver's license, a social security number, and I have an employment authorization card. My fiance and I are not living together until our church wedding for religious reasons. We are both Christian and she works at a church as well. We are thinking about getting our courthouse wedding done earlier, about 2 months in advance, so we can start the visa process. How would that affect the bona fide marriage proof, and what proof would you recommend in that case? Since we don't have a joint lease, joint loan, no kids, etc., and how much does your full service package cost? Let me answer the first portion of the question. The second portion of the question, it all really, costs-wise, I can't discuss here because it all really does depend on a case-by-case basis. If that's something that you're interested in, please contact me and we'll set up a consultation so that we can really roll up our sleeves and discuss what your options are. But to go back to your first question, can I start my green card process if I'm not yet living with my spouse? For religious reasons, for we work in different areas. I live in San Francisco. My husband lives in LA, but we do see each other regularly. I would say if it's a 2-month period that you're waiting to move in, I would recommend that you hold off on filing the green card application until you're physically living with one another. Because it is quite a big red flag to USCIS if people are filing green card applications and they're not yet living with their spouse. Again, the government would like to see that the individuals that are applying for the application are married because they love each other, and they're doing this for no reason other than for love. They don't want to see individuals filing green card applications for green card purposes. For a 2-month period, I would say prepare your application in its entirety. Once you get married and you have that marriage cert, the proof of your bigger church service and the ceremony there, it's at that point in time that I would say it'll be safer for you and easier for you to file at that point in time. If you have any additional questions on that, please reach out to me and we can discuss some more. All right, next question. When granted a green card, are you required to stay for the entire time in the United States, or would it be revoked if you're not living the full time in the US? So again, this all really depends. I do not recommend people spending more than 6 months outside of the United States at a time. For example, living in the States for 5 years, living in a foreign country for 2 years, would it be removed? So the issue with this is the issue of your intention. Are you intending to abandon your green card when you're out of the United States for 2 years? With situations like this, I would recommend talk to an immigration professional about this first before you do plan on living abroad for a longer period of time. If the intention is for you to only maybe spend a couple months outside of the United States and then come back, that's fine. It does cause a couple of complications for citizenship purposes. If you have any trips outside of the United States for more than 6 months, then it restarts your citizenship clock. If you have any trips outside of the United States for 1 year, then you can start risking losing your green card, and that the government would consider that you have abandoned your green card. If you plan on having consistent trips outside of the United States for more than 6 months at a time, maybe you need to be gone for a year, maybe you need to be gone for 2 years, then I would recommend looking into a re-entry permit to allow you to have an extended time outside of the United States. With that, you need to prove that you're not abandoning your green card. You still have property in the US, you have bank accounts, you're filing your taxes, you plan on coming back. But for 2 years, maybe for 1 year, you need to be abroad. So with that one, I would say we can set up a consultation. Let's talk a little bit more specifically about what your fact pattern is, what is involved in everything, and then I can help give you more advice from there. It doesn't sound like you're going to address marriage to someone who did not enter legally. I did. If you missed it, I'm very sorry. I touched upon it very briefly thereafter. If you have more questions about it, please reach out to me and I would love to explore your options a bit further. But there is hope. Okay, moving on. For people who have not entered legally, do you suggest a FOIA request, FBI search, or other inquiry to determine their record with USCIS, assuming they have had some interaction with border enforcement, but not necessarily a deportation? Absolutely. So at any point in time, if I have any concerns or fears with people who have, maybe you've even entered legally, and there's some concerns about border apprehension, about crimes, about anything, I will always request or recommend filing a FOIA first, getting your fingerprints done. It doesn't necessarily trigger any complications if you file a FOIA, but absolutely, yes, FOIAs are incredibly helpful because sometimes maybe you forgot something. Maybe you forgot that you were apprehended at the border, or maybe you're not entirely sure exactly what happened. Filing a FOIA and having an immigration attorney taking a look at it for you is critical, because the last thing that any attorney wants to do is put their clients at risk. So sometimes I necessarily do have to give bad news, I feel, to individuals who don't qualify. And you kind of just have to explain to them, I'm filing an application will put you more at risk than you are right now. So it's reality of the fact. Doing a FOIA is an absolutely a good idea. If you have more questions, please reach out to me. Can you talk about travel restrictions during the application? If I apply in Australia, can I still travel to the United States during the application process? That is a fantastic question. I actually will touch upon that for both. If you're filing the application in Australia, can you come to the United States as a visitor? Sure, you can. You just may have a little, an eyebrow raised from a Customs and Border Patrol officer upon your entry of, why are you coming and visiting the United States when you have a green card application pending? Simple answer, well, I want to see my spouse while I wait for my green card to be adjudicated. It takes about 1.5 years. I don't want to be apart from my spouse for that long. I'm coming to visit. Here's my return flight itinerary. Here's proof that I'm still working there. It's just a temporary trip, and then I'm going to go back at the end of this trip so that I can continue my green card application at the consulate abroad in Australia. What about if I'm filing a green card application here, an adjustment of status in the United States? Can I travel then? Again, with this one, it depends. Once you file the green card application, again, about 6 to 7 months after we file the application, you do have authorization to work internationally and work in the United States and travel internationally with the combo card that is given to you through the application process. I typically tell clients, try not to travel because you'll be stuck in secondary inspection on your way back. But you have that option. I always talk with my clients before they do have any travel plans. But if you travel if you cannot travel internationally while you're waiting for that combo card, if you travel before you receive that combo card, you do risk abandoning your green card application. So please be mindful of that as well. Next question, is there a requirement under public charge that the entrant has a degree? It's not a requirement. All of the various elements under the totality of circumstances are viewed at as a whole. They're looked at in a totality, and the adjudicating officer at the end of the day has discretion to determine, do we want to allow this person to enter the United States or not? So it's not a requirement, no, not whatsoever. But it is something that is considered in the totality now. Next question. I have an H-1B right now through my employer, and I am married to a United States citizen. once I get my work permit, is it safe to quit my job? With this one, I practice immigration conservatively. I like to play things on the safe side just because current administration is a wild card. I always tell people, if you have H-1B status, if you have L status, if you have any status whatsoever, maintain that until you have that green card in hand. Once you have that green card in hand, quit your job. Until then, maintain your status. If you need to renew your H-1B, renew your H-1B. It's just, it's safer to do that, because in the event the green card application is denied, hopefully it's not, probably it won't be, but in the event that it's denied, you have that safety net to fall back on. So don't quit your job. Try to maintain your status. I'm a United States citizen. When I get married with my fiance, would I need to be able to sponsor both my fiance? Would I need to be able to sponsor both my fiance and her parents? Or would my spouse need to have a green card or be a United States citizen before can sponsor her parents? So you cannot sponsor for your in-laws. Your fiance would have to, you guys would have to first get married. Your fiance gets her green card, and then she can become a citizen again. So your fiance would be eligible for citizenship in 3 years instead of 5 years, because she would be married to a United States citizen. Once she is a citizen herself, then she can go through the exact same process that you initially went for her. She can do it now for her parents. My partner and I just recently got married. Should I wait until we have a joint bank account and legally change my last name to begin the process with you, so we have more proof? With this, it really all depends. I would say maybe. I would say you don't need a bank account to get the process started with us. I would say have a conversation with me. We'll look at all of the documents that you do have. Maybe you have sufficient documents already. And we don't know. Maybe you start the process and we look at your documents, we put your package together and we say, you know what, we're a little bit worried that your case is not strong enough. We want to put a strong application for you. Can you provide us more documents? If you say, I don't have those documents, we'll help kind of pick your brain to see what other documents you can get in order to make your case stronger. All right, a couple of more questions. Perfect. To add on to the question that was just asked, how would your honeymoon be affected by a pending case? I have had to cancel many honeymoons for clients because of this purpose. Please hold off on scheduling any honeymoons until maybe after you get your green card, or at the very least, do not schedule it until you have that combo card, which gives you the international travel authorization. Until then, it breaks my heart when somebody says, but I have my honeymoon scheduled. What about it? And I say, I'm so sorry. You either have to pick, do you want your green card, or do you want to go to Bora Bora? So think twice before you schedule and make plans for your honeymoon. All right. Sorry, this is a continuation. Can I send in the forms and go on my honeymoon to whatever country it may be? No, don't schedule your honeymoon yet. We don't want you to abandon your green card, but we can talk a bit more about that because there's a couple of nuances, but no, don't go on your honeymoon. And then the last question, no, 2 questions. Ooh, more questions. Our time is up here. How many cases, I'll answer the last 2 questions. One of the questions is, what is my consultation fee? My consultation fee is $300 for 30 minutes. Contact us, let's chat, let's talk, and we can see what you're eligible for. The next question, I'm a Nigerian citizen currently working in Australia on a work visa. If I come into the United States on a B1, B2 visa during my brief 6-month stay and I get married sincerely, would that qualify me for a green card? Yes, absolutely. You would qualify for a green card. And then, Have you had cases denied? What did your firm do in those cases? Knock on wood, I have not had a case denial. I can't guarantee any results for anybody, but I pour my heart and my soul, and our entire team pours their hearts and their souls in these cases to make sure that we're putting together strong applications for people who are eligible. If you are not eligible, we will let you know, because we don't want to put you in harm's way. So what does our firm do in those cases? We have not been faced with that. But if you have any concerns, please reach out to me and we can chat some more. Thank you all so much for joining me today. If you have any questions, please feel free to reach out to us. You can contact us at hello@alcorn.law. Our phone number and our website is all there. Please feel free to reach out to us. I would love to speak with you all. Thank you so much and have a good weekend.